Greetings from Warsaw. In this episode of News from Poland Business and Law, Piotr Ząbkiewicz, attorney at law, senior associate in Wardyński Partners M&A practice, will talk about a new, useful type of company division. Piotr supports clients in M&A, private equity and joint venture transactions, including cross-border, as well as in corporate transformation projects. After that, news about the Polish economy.
On 15 September 2023, an amendment to Commercial Companies Code entered into force, introducing into the Polish legal system a previously unknown method of demerging companies, the demerger by spin-off. Clients are often interested in this new kind of demerger, and we have already implemented it in practice. A demerger by spin-off involves a transfer of a portion of the assets of a demerged company, which may be a limited liability company, joint stock company, or a joint stock limited partnership, to an existing or newly formed acquiring company or companies. In exchange for the transferred assets, the demerged company receives shares in the acquiring company. As a result of the demerger, the acquiring company enters into the rights and obligations of the demerged company specified in the demerger plan. It is the so-called universal succession, including all rights and obligations of the demerged company provided for in the tax law. Permits, licenses and concessions related to assets assigned to the acquiring company are transferred as well. The acquiring company can be either an existing company, joint stock limited partnership, or a company newly formed in connection with the demerger by spin-off. The main difference between the existing long-established demerger by separation and the newly introduced demerger by spin-off is that the shareholders of the demerged company do not take up shares in the company to which the assets of the demerged company are transferred. Instead, newly created shares in the acquiring company are taken up directly by the demerged company. In its essence, demerger by spin-off is very similar to contribution in kind. In both cases, a company transfers its assets and in return receives shares in the company that acquires the assets. Despite those similarities, demerger by spin-off has significant advantages over contribution in kind. As a rule, an in-kind contribution includes solely assets. In contrast, in the event of demerger, the company's span of items include both assets and liabilities, for example, contractual obligations. With an in-kind contribution, singular succession, contribution of individual assets to the company, takes place. This will usually require additional agreements between the company and its creditors to transfer assets. The broad tax succession does not take place, and permits and concessions will have to be transferred one by one. Similar restrictions will also apply to the disposal of an enterprise or an organized part of an enterprise. The advantage of a demerger by spin-off is the transfer of rights and obligations by virtue of law, partial general succession. The effect of general succession will be the transfer of most permits, concessions and tax exemptions. Due to the foregoing simplifications, a demerger by spin-off may be an interesting alternative to carrying out a reorganization in a group of companies, which under previous law would have to be carried out by a demerger by separation, in-kind contribution or transfer of an enterprise. When is it a good idea to choose the demerger by spin-off? During the company's existence, there are many situations where it is necessary to carry out restructuring. The reasons may include a need for refinancing of operations, a need to isolate specific business lines to optimize processes, starting joint venture with another company, or the need to spin off part of the existing business in order to sell it. Preserving the existing ownership structure after reorganization may also be important, for example, for regulated entities in the capital market, such as investment fund companies, and financial institutions such as banks, which will not be obliged to obtain a decision from the Polish Financial Supervision Authority, which might have to be obtained in the event of change in shareholders. Also, against the backdrop of state aid regulations, preservation of the existing ownership structure by a company that is the beneficiary of state aid may, at least in some situations, allow the state aid to be maintained, while avoiding the need to notify or obtain approval from the financing institution. Suppose a parent company spins off part of its business to a 100% owned subsidiary, but the subsidiary has already been granted a number of permits that would have to be updated in the event of change of shareholders, direct change of control. In such scenario, if a demerger by separation were to take place, a need to update the permits would occur, as the shares in the subsidiary would pass to the shareholders of the parent's company. The demerger by spin-off allows the parties to avoid updating the permits, as in that scenario the ownership structure of the subsidiary will remain unchanged. How quickly this kind of reorganization can be conducted? Depending on the assumptions made, allowing for the tax requirements such as obtaining interpretations, it should be possible to carry out a demerger by spin-off within a minimum of 3 to 4 months. Tax considerations should also be taken into account when choosing the appropriate form of restructuring. To maintain the tax neutrality of the process, it will most often be necessary to first internally spin off an organized part of an enterprise within the company. The choice of the right legal form for a reorganization will always be dictated first and foremost by the business needs, which must be effectively translated into the legal and tax levels. Therefore, a decision to conduct a demerger by spin-off or an in-kind contribution should be preceded by meticulous legal, business, and tax analysis. In this context, a demerger by spin-off creates new opportunities for reorganization that were not available before the change of law and are worth considering at the initial planning stage.
Finally, Poland has regained access to EU funds after 3 years. At the end of February this year, the European Commission unblocked €137 billion that had been blocked in 2021 due to rule of law violations by the previous government. The Commission's main allegation was that the system of disciplinary responsibility for judges led to the politicization of the Polish judicial system. The unblocking of these funds is so far the biggest success of the new government, sworn in by the President in mid-December 2023. This money, in the form of grants and low-cost loans, will be spent on the modernization and expansion of energy infrastructure, on digitization and on new tram and rail routes, creating hundreds of thousands of jobs in innovative sectors of the economy. In Poland, EU money has always been invested diligently, as can be seen when driving on motorways. However, Poland is soon to join the European Public Prosecutor's Office, which was created in 2021. It is tasked with investigating crimes against the EU budget, and this will provide an additional safeguard against the embezzlement of EU money. Thank you for watching the program. See you soon.